Imagine two men sitting in a dhaba late at night. One says to the other, Yar, let's rob the bank on MG Road next Friday. The other one nods and says, Deal. They shake hands. Now, no robbery happened, no weapon was bought, no bank was touched. Can the police arrest these two men right now at this very moment just for having this conversation? The answer is yes, and that answer changes everything you thought you knew about criminal law. Because up until this point, every criminal law principle you have studied tells you there must be an act, there must be a harm, there must be a victim. The law does not punish thoughts, the law does not punish intentions, but here, the law punishes a conversation, the law punishes an agreement. That agreement, that handshake, that nod, that itself is the crime. That is criminal conspiracy. And this is not a small, obscure corner of criminal law. Criminal conspiracy is one of the most powerful, most frequently used tools in the hands of a prosecutor. Organized crime cases, terror financing cases, corporate fraud cases, drug trafficking cases, almost every major criminal case you will ever read about has a conspiracy charge somewhere inside it. So you need to understand this not just theoretically, but surgically. Let us start with the statutory definition. Section 120A of the Indian Penal Code tells you when two or more persons agree to do or cause to be done, firstly, an illegal act, or secondly, an act which is not illegal by illegal means. Such an agreement is called a criminal conspiracy. Read that one more time. Two or more persons, an agreement, either to do an illegal act or to do a legal act but through illegal means. Now Section 61 subsection 1 of the Bharatiya Nyaya Sanhita, which is the new code that replaces the IPC, carries forward this exact same definition. The language is virtually identical, so when you are reading older judgments citing Section 120A IPC and newer material citing Section 61 BNS, they are the same provision in substance. Do not let the section numbers confuse you. Now here's the first thing you must burn into your memory. Section 120A has a proviso. A proviso means an exception or a condition attached to the main rule. The proviso says, no agreement, except an agreement to commit an offense, shall amount to a criminal conspiracy unless some act besides the agreement is done by one or more parties to such agreement in pursuance thereof. Let us break this down because this is where most students lose marks. There are two categories inside Section 120A. Category 1, agreement to commit an offense. For this category, the agreement itself is enough. The moment two people agree to commit an offense, conspiracy is complete. No overt act, no further step, nothing else needed. Category 2, agreement to do an illegal act that is not an offense, or agreement to do a legal act by illegal means. For this second category, you need something more. You need at least one overt act, one physical step, done by at least one of the parties in furtherance of that agreement. So in our dhaba example, the two men agreed to commit robbery, which is an offense under Section 378 IPC. That falls into Category 1. The agreement alone is enough. They can be arrested right there, right then, with nothing else having happened. But suppose instead they agreed to file a civil suit, a perfectly legal act, but they plan to do it by bribing the court clerk to falsify records. Filing a civil suit is legal, but the method, bribery and falsification, is illegal. That falls into Category 2. For a conspiracy charge to stick here, you would need to show that one of them actually went and bribed the clerk or took some real step toward it. Now ask yourself, why does this distinction exist? Why does the law treat these two categories differently? Think about it. An agreement to commit an actual offense, say to murder someone, is inherently dangerous from the very first moment. The moment two people commit to that plan, the threat becomes real, the danger is concrete. But an agreement to pursue a legal objective through potentially improper means, that is more ambiguous. People agree to do legal things all the time. The law requires you to show a concrete step was taken before it calls that a conspiracy. It is a safeguard against overcriminalization. So we have the definition. But now you must be asking, why does this provision even exist? Why did the legislature feel the need to make conspiracy a separate, standalone offense at all? This is the legislative history question, and it is more interesting than it sounds. Before 1913, there was no provision in the Indian Penal Code that made criminal conspiracy a standalone punishable offense. Let that sink in. The original IPC of 1860, drafted by Macaulay, did not have Chapter VA at all. There was Section 107, which dealt with abetment by conspiracy, but that provision only operated when the actual offense was committed or attempted. If the conspiracy never materialized into action, Section 107 could not catch it. So here's the gap. Two men plan a murder. They take every step of preparation. They buy poison, they case the victim's house, they assign roles. And then, for whatever reason, maybe they get cold feet, maybe something goes wrong, they do not actually commit the murder. Under the old framework, you could not prosecute them for conspiracy because the offense was never committed, because the substantive provision, Section 107, needed a completed offense as its anchor. Prosecutors were frustrated, courts were frustrated, law enforcement was frustrated. There was a gap in the law that sophisticated criminals were exploiting, and particularly in the context of organized group criminality, dacoity gangs, seditious conspiracies, organized fraud, the old law was clearly insufficient. So in 1913, through the Criminal Law Amendment Act, Chapter VA was inserted into the IPC. Sections 120A and 120B were added, and with that insertion, criminal conspiracy became a substantive offense, meaning it can be prosecuted entirely on its own, independently, without needing any underlying offense to have been committed or attempted. This is the core shift. Pre-1913, conspiracy was parasitic. It lived only on the back of a completed offense. Post-1913, conspiracy became autonomous. It stands alone. The agreement itself is the crime. Now the BNS in 2023 carries this forward. Section 61 of the BNS replicates the structure. The legislative intent remains the same. The historical gap that prompted Chapter VA is still the justification for Section 61 today. So why does it matter for you to know this history? Because examination questions often ask, what is the rationale for criminalizing conspiracy? And if you only say, because the law says so, you will lose marks. The correct answer connects to this history. The law recognized that group criminality creates a danger that justifies intervention before any harm actually occurs. Now let us go deeper into that rationale, because this is the conceptual heart of the entire topic. The law generally follows a principle, actus reus. There must be a guilty act. You are not punished for thinking about stealing. You are not punished for imagining a fraud. The act must happen. But criminal conspiracy is a deliberate exception to this principle, and the exception is justified on a specific ground. The ground is this: a combination of persons to commit a crime is qualitatively more dangerous than any individual acting alone. When you add a second person to a criminal plan, you do not just double the danger, you multiply it. Here is why. First, mutual encouragement. Once two people commit to a plan together, each one reinforces the other's resolve. It becomes harder for either of them to withdraw. Second, division of labor. A single person planning a complex crime, say a bank robbery, faces enormous practical obstacles. Multiple conspirators can divide roles, share expertise, and execute a plan that no individual could manage alone. Third, concealment capacity. A group is far better at covering tracks, creating alibis, and evading detection than any individual. So the law says, we are not going to wait until this dangerous combination causes harm. We are going to intervene at the agreement stage itself. This principle has been articulated clearly by the Supreme Court of India in multiple cases. In State v. Nalini, which is one of the landmark judgments on conspiracy arising from the Rajiv Gandhi assassination case, the court observed that the very agreement to do an illegal act is the gist of the offense of conspiracy. The actual commission of the illegal act is not necessary. Now here's a question for you. Think carefully before I give you the answer. If the object of the conspiracy is ultimately not achieved, if the plan fails completely, does the conspiracy charge still hold? Yes, absolutely yes. The failure of the ultimate object has no bearing on the guilt for conspiracy, because the offense was complete the moment the agreement was formed. Whether the plan succeeded, failed, or was abandoned, irrelevant. The conspiracy itself was committed the moment two or more minds agreed on the criminal purpose. This is tested directly in MCQs. The classic pattern is A and B agree to murder C. Before they can act, C dies in an accident. Are A and B guilty of conspiracy? Answer, yes. The object became impossible, but the conspiracy was complete at the moment of agreement. Now let us talk about something that confuses almost every student when they first encounter this chapter. What exactly constitutes an agreement for the purposes of Section 120A? The agreement does not need to be formal. It does not need to be written. There is no requirement of a contract, no signatures, no explicit verbal oath. The Supreme Court has repeatedly held that a conspiracy can be inferred from the conduct of the parties, the circumstances of the case, and the pattern of events. Circumstantial evidence is sufficient. Think about what this means in practice. 5 people, each playing a separate role in a bank fraud. One forges documents, one processes the loan, one provides a fake guarantor, one arranges for the money to be siphoned, one creates a shell company to receive funds. Not one of them ever sat in a room together and said, "We are in a conspiracy." But the pattern of coordinated conduct, the division of roles, the shared objective, the court can infer a conspiracy from all of this. This is actually what makes criminal conspiracy such a powerful prosecutorial tool. You do not have to produce a smoking gun recording of people agreeing to commit a crime. You assemble the circumstantial evidence and prove the meeting of minds. Now here is the next critical ingredient. 2 or more persons. Conspiracy is by definition a group offense. You cannot conspire alone. This seems obvious but has important legal implications. What happens when all alleged conspirators except one are acquitted? This is a classic MCQ trap. The general principle is, if only one person remains convicted of conspiracy, the conviction cannot stand, because conspiracy requires at minimum 2 parties. If co-conspirators A, B, and C are all charged, and A and B are acquitted, C alone cannot be convicted of conspiracy, because C alone cannot have conspired with himself. However, and this is important, this is not an absolute rule. If the acquittal of co-conspirators is on technical grounds, or on grounds that do not go to the existence of the conspiracy itself, the remaining accused can still be convicted. The courts look at the substance of why the co-accused were acquitted. Now let us also address the punishment structure, because Section 120B IPC, which is Section 61 subsection 2 of BNS, tells you the punishment. If the conspiracy is to commit an offense punishable with death, imprisonment for life, or rigorous imprisonment for 2 years or more, the punishment for conspiracy is the same as for the offense itself, even if there is no specific provision made for the conspiracy. If the conspiracy is to commit any other offense, the punishment is 6 months imprisonment, or fine, or both. So here's the exam pattern. A and B conspire to commit murder. Murder under Section 302 IPC is punishable with death or life imprisonment. What is the punishment for the conspiracy? Same as murder, death or life imprisonment under Section 120B. They do not need to have actually killed anyone. And now you see the full picture of why this provision is so powerful. The agreement to commit the most serious crimes carries the same punishment as the crime itself, even if the crime never actually happens. Now step back and ask, what is the basic legal objective behind all of this? It is early intervention in group criminality. The legislature made a deliberate policy choice. We are not going to wait for the bomb to go off. We are going to defuse it while it is still being assembled. The moment the agreement crystallizes, the moment 2 or more persons commit, in their minds, to a criminal purpose, the state acquires the power to intervene. This is not about punishing thoughts. It is about recognizing that a committed criminal combination is itself a threat to public order, and the law must have the tools to address it before irreversible harm occurs. That is the entire philosophical and legislative foundation of Sections 120A and 120B IPC, now Section 61 of the BNS. An agreement is not just preparation. An agreement between criminals is itself the danger, and that is why the law made it a crime.